as I will do shortly. I was conscious of the fact that in the event of disallowing the objection, then the matter would still have to proceed for hearing on merit. This would mean more utilization of court's valuable time and a likelihood of not concluding the case before October 26, 2017. In so directing, I consider that exercise of judicial authority is now entrenched in the Constitution, which commands this court earlier being guided by the principles enumerated in Article 139, among whom justice shall not be delayed. Article 5 of the Constitution of Kenya, Protection of Rights and the Fundamental Freedoms and Procedure 2013, which provides for inter alia timely disposal of proceedings. Petitioner's advocate submissions. On jurisdiction, the petitioner's counsel asked the court to determine this petition on merit, adding that the 2013 Raila case did not make a final determination on who is eligible to participate in a fresh election in the event of by the court, and that the paragraph relied upon by the respondent is an obiter dictum and therefore has no presidential value. He cited William M. Lille et al., where the author observed that, strictly speaking, an obiter dictum is a remark made or opinion expressed by a judge in his decision upon cause, by the way, that is incidentally or collaterally, and not directly upon the question before the court, or it is a statement of law enunciated by the judge or the court merely by way of illustration, argument, analogy, or suggestion. End of quote. We submitted that the question of who is eligible to participate in a fresh election was not an issue for determination in the 2013 Raila case, and that the comments in question were an opinion made at the request of the Honorable Attorney General as amicus curiae, who sought directions on the matter. It was not a pleaded issue, it was not deliberated, nor was it decided on merit. Counsel argued that the scenario contemplated in 2013 Raila case can be distinguished from the present case in that the petitioner actively participated in the petition that led to the nullification of the election results as an interested party, and that the position of an interested party was well captured by the Supreme Court in the case of Francis K. Muruachechu, where the court observed, and I quote, "Interested party is one who has a stake in the proceedings, though he or she was not a party to the cause ab initio. He or she is one who will be affected by the decision of the court when it is made either way. Such a person feels that his or her interest will not be well articulated unless he is himself or she herself appears in the proceedings and champions his or her cause." End of quote. On the nature and effect of fresh election envisaged under Article 140 sub-Article 3 of the Constitution, counsel sought to distinguish the various scenarios envisaged in Articles 138 sub-Article 4 and 5 of the Constitution, which are different from Article 140 sub-Article 3, which stipulates a fresh election after the results are nullified by the court. Counsel cited the Honorable Justice Professor Otieno Dek in his paper entitled Election Technology, Law and the Concept of, quote, "Did the irregularity affect the result of elections," end of quote, where the learned professor had this to say, quote, "Once the machinery of election dispute resolution has been activated, the petitioner continues for the benefit of the whole voting constituency. It is for this reason that prima facie a petition once filed cannot be withdrawn," end of quote. Thus, the beneficiaries of an election petition are not just the parties in the petition, but the whole voting constituency, and argue that there is no legal basis for restricting the fresh election to only the third and fourth respondent candidates. Counsel also argued that upon nullification, the will of the people as expressed in the election ceased to have effect and must now be subjected to fresh tests, and asked the court to find that the proper interpretation of Article 140 sub-Article 3 of the Constitution means a new presidential election, which includes the petitioner, and that its exclusion is a violation of the petitioner's rights under Articles 38 and 27 of the Constitution, and also violates Articles 1, 2, 4, 10, 47 and 140 of the Constitution. first respondent advocate submissions. Counsel for the first respondent submitted that the first respondent was guided by the Supreme Court decision in the 2013 Raila case and argued that in the said case the court found that, quote, fresh election conducted pursuant to Article 140 Article 3 of the Constitution would have the following features. 1. Can only involve the persons who participated in the original invalidated election, and there would therefore be no fresh nominations. 2. If the petition invalidating the election is filed by a petitioner who was one of the candidates in the original election and who had taken the second position, the fresh election shall be confined to only the petitioner and the president-elect. 3. If the petition invalidating the election is filed by a number of petitioners who were candidates in the original election, the fresh election shall be confined to those petitioners and the president-elect. For any candidate who participated in the original invalidated election and did not challenge the election of the president-elect is presumed to have conceded defeat or acquiesced to the result. Counsel submitted that the petitioner AI did not participate in the petition as a petitioner but as an interested party. He cannot contest in the fresh elections as per the above decision, and that constitutional provisions must be interpreted as a whole, and that the petitioner's rights under Articles 27 and 38 of the Constitution must be read and appreciated in concert with the constitutional rights that guarantee a free, fair, credible, and transparent elections under Articles 81 and 88 Article 4 of the Constitution. Counsel also submitted that the interpretation of Article 140 Article 3 of the Constitution by the Supreme Court is binding on this court by virtue of Article 163 Article 7 of the Constitution, and argued that the state interpretation was based on a substantive prayer before the court, hence it was not obiter dictum, and that under Article 163 Article 7 the binding nature of the Supreme Court decision is absolute regardless of whether or not the decision is either obiter dictum or ratio desdendi, and that Article 163 Article 7 is an edict firmly addressed to all courts in Kenya that they are bound by the authoritative pronouncements of the Supreme Court, and that where the issues before the court were determined by the Supreme Court, it will no longer be open to that court to examine the same with a view to arriving at a different decision. Second, respondent advocate submissions. Counsel submitted one. The applicable legal framework governing the conduct of fresh presidential elections is under Article 140 Article 3 of the Constitution as read with Part 3 of the Elections Act and the regulations. The regulations do not make provision for holding fresh elections arising from nullification of a presidential election, and Article 140 Article 3 C. The issue was resolved in the 2013 Raila case upon request for directions by the Honorable Attorney General appearing as an amicus curiae, and D. In absence of express statutory provisions, the second respondent cannot be faulted for relying in good faith on the Supreme Court's decision. The third respondent's counsel submissions. He relied on the 2013 Raila case just like the others, and added that the petitioner has no legitimate right to participate in the fresh election since he was only an interested party in the petition. B. The first respondent acted in conformity with the Supreme Court decision. C. The petitioner considered defeat. So, citing Mwai Kibaki versus Daniel Torotich Arab Moi, submitted that observations in 2013 Raila case were made after the court was invited to give directions in line with the release declared by the Constitution. The observations were not obiter dictum. Fourth respondent submissions. The fourth respondent counsel supported the petition on grounds: 1. The challenge gazette notice offends the petitioner's right to equal protection under the law. 2. The fact that the petitioner was an interested party in the petition as opposed to a petitioner does not deprive him of the benefits of the judgment. C. The Supreme Court's decision of 1st September 2017 is a judgment in rem which binds all persons to the extent of their interest in the subject whether or not they were parties. D. The Supreme Court did not state that the election will not involve candidates who participated in the original election. For the interested party, it was submitted that the Gazette notice conforms to the Constitution, the law, and the 2013 Raila case, and 2. The issues were settled in the said division. 3. Petition is incompetent. 4. This court lacks jurisdiction. I now proceed to analysis of the issues, the facts, the law, submissions, and determination. I put them together, as you'll notice. I proceed. So the first issue that falls for determination is whether the Supreme Court in 2013 Raila case interpreted Article 140 sub-article 3 of the Constitution. If it did, then by date of Article 163 sub-article 7, this court has no jurisdiction to delve into the matter, and it must down its tools. Article 163(7) explicitly provides that all courts other than the Supreme Court are bound by the decisions of the Supreme Court. I need not repeat that the Chief Justice, in the order referred to earlier, correctly decreed that the Supreme Court has no jurisdiction to interpret the Constitution save as stated in Article 163, 3, and 6, and added that the petitioner ought to have approached the High Court under Article 165(3)(d). Article 1633 of the Constitution provides as follows: the Supreme Court shall have exclusive original jurisdiction to hear and determine disputes relating to the elections to the office of President arising under Article 140. And subject clause 4 and 5, appellate's jurisdiction to hear and determine appeals from the Court of Appeal and another court or tribunal as prescribed by national legislation. Sub-Article 6 provides that the Supreme Court may give an advisory opinion at the request of the national government, any state organ, or any county government with respect to any matter concerning county government. Article 140 of the Constitution deals with the questions as to the validity of presidential elections, which the learned Chief Justice observed is a matter within the original jurisdiction of the Supreme Court. The issue presented in this petition is not a question as to the validity of presidential elections, no, but a question on the interpretation of what constitutes a fresh election. Thus, the Honorable the Chief Justice was right in holding that the Supreme Court has no original jurisdiction to interpret the said provision. The jurisdiction lies in this court by dint of Article 163 sub-article 3D. Consequently, this matter is properly before this court. Also raised in this petition is the question of alleged violation of rights under Article 38 and Article 27 and other constitutional provisions, which to me is within the constitutional mandate of this court. The jurisdiction of this court on the above issues is beyond doubt. I need not mention that Article 165(1) establishes the High Court and vests in it vast powers, including the power to determine the question whether a right or a fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened, and the jurisdiction to hear any question respecting the interpretation of the Constitution. Article 23(1) provides that the High Court has jurisdiction in accordance with Article 165 to hear and determine applications for redress of a denial, violation, or infringement of or a threat to a right or a fundamental freedom in the Bill of Rights. Article 1656 provides that the High Court has supervisory jurisdiction over the subordinate courts and underlining over any person or body or authority exercising a judicial or quasi-judicial function. In the words of Chief Justice Marshall of the United States, quote, "It is most true that this court will not take jurisdiction if it should not, but it is equally true that it must take jurisdiction if it should. The judiciary cannot, as the legislature may, avoid a measure because it approaches the confines of the Constitution. We cannot pass it by because it is doubtful. With whatever doubts, with whatever difficulties a case may be attended, we must decide it if it be brought before us. We have no more right to decline the exercise of the jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution. Questions may occur which we would gladly avoid, but we cannot avoid them, or we can take our best judgment and consciously perform our duty." End of quote. In view of the clear provisions of Articles 163, 3, 6, and 140, and guided by the order by the Honorable the Chief Justice produced above, and bearing in mind that the Honorable the Chief Justice was fully aware of the Raila case, I am not persuaded that the observation by the Supreme Court in the 2013 Raila case were or was an interpretation of Article 3 because the jurisdiction to interpret the said provision lies in the High Court, not the Supreme Court. Thus, on the face of such clear constitutional provisions, it was not possible for the Supreme Court to exercise a jurisdiction they do not possess. It is important to address the question whether or not the observations by the Supreme Court were obiter dictum or ratio desdendae. The said observations and the clear provisions of Article 1637 brings to the fore the important doctrine of precedent, a core component of the rule of law, without which deciding legal issues would be directionless and hazardous. Deviation from it is to invite legal chaos. The doctrine is a means to an end. The doctrine of precedent is widely recognized in developed legal systems. It has been described as a manifestation of the general human tendency to have respect for experience. Its importance is captured in the following passage, quote, "In the legal system, the cause of justice are paramount, the maintenance of certainty of law and of equality before it. The satisfaction of legitimate expectations entail a general duty of judges to follow the legal rules in the previous judicial decisions. The individual litigant would feel himself unjustly treated if a past ruling applicable to his case were not followed, where the material facts were the same. This authority given to past judgments is called the doctrine of precedent. It enables the citizen, if necessary with the aid of practicing lawyers, to plan his private and professional activities with some degree of assurance as to their legal effects. It prevents dislocation of rights, particularly contractual and property ones, created in the belief of an existing rule of law. It cuts down the prospect of litigation. It keeps the weaker judge along right and rational facts, drastically limiting the play allowed to partiality, caprice, or prejudice, thereby not only securing justice in the instance, but also retaining public confidence in the judicial machine through like being dealt with alike. Certainty, predicability, reliability, equality, uniformity, convenience. These are the principal advantages to be gained by a legal system from the principle of stare decisis, end of quote. I can also borrow from the eloquence of Cameron J.A. He said, and I quote, "The doctrine of precedent, which requires courts to follow the decision of courts, coordinate and higher courts, is the judicial hierarchy. In the judicial hierarchy is an intrinsic feature of the rule of law, which is in turn foundational to our constitution. Without precedent, there would be no certainty, no predicability, no coherence. The courts would operate in a tangle of unknowable considerations, which all too soon would become vulnerable to whim and fancy. Law would not rule. The operation of precedent and its proper implementation are therefore vital constitutional questions." End of quote. The doctrine of precedent decrees that only the ratio desdendae of a judgment and not the obiter dicta are binding effect. The fact that obiter dicta are not binding does not make it open to courts to free themselves from the shackles of what they consider to be unwelcome authority by artificially characterizing as obiter what is otherwise binding precedent. Only that which is truly obiter may not be followed, but depending on the source, even obiter dicta may be of potent persuasive force and only be departed from after due and careful consideration. The controversy raised by the observation in the 1013 trailer case raises a few issues. The first is whether the said observation is obiter. Even if it is highly persuasive, coming from, as it does, from the highest court in the hierarchy of our courts, but it is not binding underlining. Literal obiter are things said by the way or in passing by a court. They are not pivotal to the determination of the issue, or issues at hand are not binding precedent. They are to be contrasted with the ratio desdendae of a judgment which is binding. Regarding this concept, Scripture J.A. had the following to say, quote, "It may be that the contrast between a reason and the ratio depends mainly on the meaning attached to those words in their context by the users. Where a single judgment is in question, the reasons given in the judgment, properly interpreted, do constitute the ratio desdendae, originating or following a legal rule provided A, that they do not appear from the judgment itself to have been merely subsidiary reasons for following the main principle or principles. B, that they were not merely a course of reasoning on the facts, and C, which may cover A above, that they were necessary for the decision, not in the sense that it could not have been reached along other lines, but in the sense that along the lines actually followed in the judgment, the result would have been different but for the reasons. End of quote. It is admitted that the Supreme Court was responding to a question raised by the Honorable Attorney General, who sought the court's guidance on what would happen should the court allow the petition, bearing in mind that the petition was the first in the country. The Honorable Attorney General was an amicus curiae in the case. The issue was not raised by the petitioner or the respondent, nor did it arise from the pleadings. It was not a pleaded issue. Paragraph 286 of the judgment clearly states that, quote, the Honorable Attorney General, as amicus curiae, invited the court to give directions on a line of relief declared by the Constitution depending on the finding on merit. In my view, the invitation was for the court to give directions on a line of relief depending on finding on merit, and it was not one of the issues for determination in the dispute before the court. The directions are not part of the final orders of the court. In my view, they cannot be said to be ratio decidendi of the case. The role of amicus curiae is to draw the attention of the court to relevant matters of law and the fact to which attention would not otherwise be drawn, in return for the privilege of participating in the proceedings without having to qualify as a party. An amicus has a special duty to the court. That duty is to provide conscient and helpful submissions that assist the court. The relevant passage in the 2013 Raila case reads, it's fairly long, but I'll read about 4 paragraphs. 289 from the judgment, it is clear that a fresh election under Article 140 sub-Article 3 is triggered by the invalidation of the election of the declared president-elect by the Supreme Court following a successful petition against such decision. I've underlined the next sentence. Since such a fresh election is built on the foundations of the invalidated election, it can, in our opinion, only candidates who participated in the original election. There's a reason I've underlined that. In that case, there will be no basis for a fresh nomination of candidates for the resultant electoral contest. 290. Suppose, I've underlined the word suppose because I'll be talking about it later. However, that the candidates or candidates who took part in the original election dies or abandons the electoral quest before the scheduled date, then the provisions of Article 138(1)(b) would become applicable with the fresh nominations ensuing. 291. Barring the foregoing scenario, that the fresh election contemplated under Article 143 bear the same meaning as the one contemplated under Article 138(5) and 7. The answer depends on the nature of the petition that invalidated the original election. If the petitioner was only one of the candidates who had taken the second position in the vote tally for the president-elect, then the fresh election will in law be confined to the petitioner and the president-elect. And all the remaining candidates who did not contest, who did not contest, the election of the president-elect will be assumed to have either conceded defeat or acquiesced in the results as declared by IEBC, and such candidates may not participate in the fresh election. 292. Such, indeed, is the situation in the instant case. It follows that if this court should invalidate the election of the third and fourth respondents, only the first petitioner would participate as a contestant in the fresh election, whereas the president-elect and the candidate who receives the most votes in the fresh election would be declared elected as president. 293. But suppose, I've underlined the word suppose again. A successful petition challenging the president-elect were filed by more than one candidate who had participated in the original election. The only candidates in the fresh election in such a case, in our opinion, would be the petitioner as well as the declared president-elect whose election had been annulled. 294. Suppose, another suppose. Further, that the election of a declared president-elect is annulled following the petition of a person who was not a candidate in the original election. In such a case, in our opinion, each of the president-elect candidates in the original election would be entitled to participate in the fresh election, and no fresh nominations would be required. At its most fundamental level, the ratio decidendi of a judgment has been defined as the reason for the decision. The decision be the order of the court. it has been suggested that the more accurate description is the principles of the decision. In Asbury's Laws of England, it is described as the general reasons given for the decision on the general grounds on which it is based, detached or abstracted from the specific peculiarities of the particular case which gives rise to the decision. Whatever the reasons for the decision may be, it is the principle to be extracted from the case, the ratio decidendi which is binding, and not necessarily the reasons given for it. As observed in paragraph 45 above, the reasons given in a judgment, properly interpreted, do constitute the ratio decidendi, originating or following a legal rule, provided one, they do not appear from the judgment itself to have been merely subsidiary reasons for following the main principle or principles. Two, that they were not merely a course of reasoning on the facts, and C, which may cover A, as I said earlier, they were necessary for the decision, not in the sense that it could not have been reached along other lines, but in the sense that along the lines actually followed in the judgment, the result would have been different for the reasons. In my view, in applying the above reasoning, the observation by the Supreme Court must be viewed as obiter and not ratio decidendi of the decision. The court's observation itself supports such a characterization. The court used the word suppose, I'll put it in quotes, not less than 3 times while giving, quote, hypothetical situations to explain several scenarios to support its opinion. This confirms it was a mere opinion, hence it was obiter, hence not binding to this court. The obiter of the highest court is ordinarily persuasive to this court. A close examination of paragraph 289 actually shows that it's supposed the position taken by the petitioner that having participated in an invalidated election is entitled to contest. Let me read that paragraph 289 again. It is clear that a fresh election under Article 140 sub-Article 3 is triggered by the invalidation of the election of the declared president-elect by the Supreme Court following a successful petition against such election. Since such a fresh election is built on the foundations of the invalidated election, it can, in our opinion, only involve candidates who participated in the original election. I can even end there. In that case, there will be no basis for fresh nomination of candidates for the resultant electoral contest. That is paragraph 289, if I were to be persuaded by it. Clearly, if the first and second response were guided by the Supreme Court's opinion, they cannot choose the paragraphs that favor them and ignore paragraph 289 reproduced above. The other issue is whether, in line with the said opinion, the petitioner contested the invalidated election in court. It is not disputed that the petitioner was admitted as an interested party in petition number 1 of 2017 that led to the nullification of the results. He supported the petition. The position of the interested party was all captured by the Supreme Court in the case I cited earlier, authored by Mr. Mutuma, Francis K. Muruatetu, where the court observed, I'll repeat it, quote, interested party is one who has a stake in the proceedings, though he or she was not a party to the cause ab initio. He or she is one who will be affected by the decision of the court when it is made. Either way, such a person feels that his or our interest will not be well articulated unless he himself or she herself appears in the proceedings and champions his or her cause. End of quote. To construe the statement by the Supreme Court to mean an interested party supporting a petition should not benefit from the decision of the court would, in my view, be jurisprudentially wrong. To the extent that the interested party supported the petition, then in my view, he contested the results of the election. The next issue is whether the Supreme Court interprets Article 140 sub-Article 3 of the Constitution. Firstly, the answer is no. As explained above, the Supreme Court has no jurisdiction to interpret the provision. Its mandate is limited to the earlier cited provisions. Secondly, as pointed above, the text relied upon is an obiter. It was an opinion rendered at the request of the Honorable Attorney General. It was not a pleaded issue canvassed by the parties to the suit. Thirdly, and most important, disposition of issues relating to interpretation of the Constitution and determining constitutional questions must be formidable in terms of some constitutional principles that transcend the case at hand and is applicable to all comparable cases. There is no way the apex court in the land would have approached such a grave constitutional issue in such a manner, using hypothetical situations and words such as suppose, to illustrate their point. They were merely rendering an opinion, period. Court decisions cannot be ad hoc. They must be justified and perceived as justifiable on more general grounds reflected in previous case law and other authorities that apply to the case at hand. The Privy Council, in the case of Minister for Health, and another, as the following to say while interpreting a constitutional provision, quote, a constitutional order is a document sui generis, to be interpreted according to the principles suitable to its particular character and not necessarily according to the ordinary rules and presumption of certain interpretation. It is important to give full recognition and effect to those fundamental rights and freedoms. End of quote. Lord Wilberforce, delivering the opinion of the court in the said case, said, quote, respect must be paid to the language which has been used and the traditions and usages which have given meaning to the language. It is quite consistent with this and with the recognition that rules of interpretation may apply to take as a point of departure for the process of interpretation, recognition of the character and the origin of the instrument, and to be guided by the principle of giving full recognition and effect to those fundamental rights and freedoms. End of what. On the correct interpretation of Article 140, Article 3, it is important to bear in mind that the starting point of interpreting the provision is the language itself. In the absence of an express intention to the contrary, the language must ordinarily be taken as conclusive. Thus, when the words are unambiguous, then this first canon is also the last. Judicial inquiry is complete. There are important principles, however, which apply to the construction of statutes, such as 1, presumption against absurdity, meaning that a court should avoid a construction that produces an absurd result. B, presumption against unworkable or impracticable result, meaning that a court should find against a construction which produces unworkable or impracticable result. C, presumption against anomalous or illogical result, meaning that a court should find against a construction that creates an anomaly or otherwise produces an irrational or illogical result. And D, the presumption against artificial result, meaning that a court should find against a construction that produces artificial result. And lastly, the principle that the law should serve public interest, meaning that the court should strive to avoid adopting a construction which is in any way adverse to public interest, economic, social, and political, or otherwise. The court is an independent arbiter of the Constitution, has fidelity to the Constitution, and has to be guided by the letter and spirit of the Constitution. In interpreting the Constitution, the court should give life to the intention of the document instead of stifling it. Article 140, Article 3 reads, quote, if the Supreme Court determines the election of the President-elect is to be invalid, a fresh election shall be held within 60 days after the determination. The Constitution has not defined fresh election, nor is it defined in the Elections Act. But by dictionary, I looked at the following. A runoff is defined as a further competition, election, race, after a tie or inconclusive result. In Kenya, the runoff is between two leading candidates in presidential elections. From these definitions, it's clear the election contemplated under Article 140 of Article 3 is not a runoff. Contemplated under Article 185 of the Constitution. It is a fresh election, as the article suggests or states. Article 140 that deals with the validity of presidential election and the petition therefrom. Article 140 deals with the validity of presidential election and the petition therefrom. It prescribes in Article 3 that if the Supreme Court determines the election of the President-elect to be invalid, a fresh election shall be held within 60 days after the determination. It is the use of the word fresh in Article 140 Article 3 that warrants a close scrutiny. In my view, the Constitution envisages a completely fresh election. However, it is important to point out that Article 138 that deals with the procedure at presidential election also has used the word fresh election when referring to what has been defined as a runoff. Article 5 states that if no candidate is elected, a fresh election shall be held within 30 days after the previous election. The fresh election referred to in this article is indeed what we know as a runoff. Further, this fresh election allows only the candidate or candidates who received the greatest number of votes, B, the candidate or candidates who received the second greatest number of votes. My understanding of the Supreme Court opinion is that they took the view that the definition of fresh election as contemplated in Article 138 sub Article 5 should be embossed on Article 140. My humble view is that if the draftsman or woman of the Constitution intended so, then the provision could have captured it in clear terms. To me, Article 140 sub Article 3 clearly talks of a fresh election. It should be remembered that the provision comes into play after the results are nullified by the court. Nullify is defined as, quote, to make void, to render invalid. Nullification is the act of making something void. Article 140 sub Article 3 uses the word invalid, which is defined as not legally binding without a basis. To me, the use of the above words require no elaboration. Hence, the use of the word fresh election, which to me is the logical and natural interpretation that flows from the use of the said words. Fresh is defined as recent, not stale, characterized by newness without any material interval. Not previously known or used, new or different. I have references for all those things I'm saying anyway. I am persuaded that the election envisaged under the above provision is a new election. The question that should follow is whether this would mean fresh nominations. It should be remembered that the same provision gives a time frame of 60 days within which the fresh election should be held. Applying the principles of interpretation enumerated above and to avoid an interpretation that may lead to absurd results, it is my view that the 6 days period may not be adequate for fresh nominations. Hence, the logical conclusion, which to me would serve public interest, is that those who participated in the invalidated elections do qualify to contest in the fresh election. The doubting task of court through judges and intricacies embedded in the discharge of judicial functions with a view to achieving justice is eloquently captured in the immortal pronouncement of Toby, Judge of the Court of Appeal of Nigeria, now I think it's in the Supreme Court, as he then was, when he said, quote, in doing justice according to law, in a situation where there is an enabling statute, a court of law should allow itself or pet itself to follow the course of a liberal interpretation of the statute to accommodate the tenets of justice, while at the same time not throwing overboard the intention of the draftsman. The day a court of law, which is also a court of justice, in the course of exercising its interpretive jurisdiction, yields to no chose to arid legalism and abandons its primary function of doing substantial justice, a crisis situation permits the entire system of administration of justice or the enforcement of a judicial process. Democracy in its shapeless and amorphous content and its twin brother, the rule of law, would be threatened in such a situation, which would definitely result in anarchy. That would be the very strange and most unhappy moment for the judiciary. I hope that day does not come. End of quote. It is a cardinal rule in constitution interpretation that provisions of a constitution concerned with the same subject should, as much as possible, be construed as complementing and not contradicting one another. The constitution must be read as an integrated and cohesive whole. To me, Articles 138, Sub-Article 5 and 8, and 140, Sub-Article 3, create separate scenarios embossing scenarios in Article 138.5 and 8 on Article 143 would be an improper interpretation because the situations are different. They are real situations, not hypothetical. It is an elementary rule of constitutional construction that no one provision of the Constitution is to be segregated from the others and to be considered alone, but that all the provisions bearing upon a particular subject are to be brought into view and interpreted as to effectuate the greater purpose of the instrument. It follows that the definition of fresh election as contemplated in Article 138 Sub-Article 5 should not be embossed on Article 140 Sub-Article 3 since different scenarios are contemplated. Having participated and supported the petition that nullified the elections, and even applying the obiter by the Supreme Court, I still find nothing to bar the petitioner from contesting the fresh elections. The next issue is whether the beyond decision violates the petitioner's constitutional rights under Article 38 and 27 of the Constitution. Article 10(2) of the Constitution provides the national values and principles of governance, which include rule of law, human dignity, equity, social justice, inclusiveness, equality, human rights, and non-discrimination, and protection of the marginalized. These principles are binding on all state organs, state officers, public officers, and all persons whenever any of them applies or interprets the Constitution, enacts, applies or interprets any law, or makes or implements public policy decisions. The Constitution provides that the Bill of Rights is an integral part of Kenya's democratic state and is the framework for socio, economic, cultural policies, and that the purpose of recognizing and protecting human rights and fundamental freedoms is to preserve the dignity of individuals and communities and to promote social justice and the realization of the potential of all human beings. It is also important to emphasize the rights and fundamental freedoms in the Bill of Rights belong to each individual and are not granted by the state. B. Do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law, except to the extent they are inconsistent with the Constitution. And C. Are subject only to the limitation contemplated in the Constitution. Article 38 of the Constitution guarantees the rights which include the right to be a candidate for public office. Undoubtedly, the right created under Article 38 in favor of the citizens of Kenya to participate in the election process is an integral part, in brackets, for the sake of convenience, I call it element, close of bracket, of the basic feature of democracy. There are two important points to note here. The first one is that the right to participation in the electoral process, which should include both voting and standing for an election, is part of the basic structure of a democratic state. This would mean that restrictions upon participation in the electoral process can only be justified through the very strong reasons and in a way that the core of the basic feature, that is democracy, is not damaged. Secondly, and even more significantly, once the rights under Article 38 and 27 are not absolute rights, they cannot be limited except by law, and then only to the extent that the limitation is reasonable, justifiable in an open democratic society. Any limitation must be subject to three-part test. 1, a limitation will only be acceptable when it's prescribed by law. 2, when it is necessary and proportionate. 3, when the limitation pursues a legitimate aim, namely the interest of national security, public safety, the prevention of disorder or crime, protection of health or morals, or the protection of the rights and freedoms of others. Article 27 of the Constitution guarantees the right to equality and freedom from discrimination. Equality of rights under the law for all persons, male or female, is so basic to democracy and commitment to human rights. The right to equal treatment and the right not to be discriminated against is the right vested in individuals. The constitutional freedom to vote and run for an office as an aspect of Article 38 is an individual freedom. Any action that specifically bars the petitioner from participating in the democratic process is unconstitutional unless it can be justified under the limitation clause. The right / freedom to vote and the right / freedom to stand for office are conceptually inseparable, as they form equally integral parts of the democratic state. The core issue for this determination now is whether the petition discloses a case to demonstrate that the decision complained of and all the reasons offered for excluding the petitioner from the presidential contest amount to discrimination within the meaning of Article 27 of the Constitution. To me, the guiding principles in a case of this nature are clear. The first step is to establish whether the Gazette notice complained of differentiates between different presidential candidates. The second step entails establishing whether that differentiation amounts to discrimination. The third step involves determining whether the discrimination is unfair. This is where the answer lies, period. I must add that if the discrimination on any of the listed grounds in Article 27(4) of the Constitution is presumed to be unfair, I must add that if the discrimination is based on any of the listed grounds in Article 27(4) of the Constitution, it is presumed to be unfair. It must be noted, however, that once an allegation of unfair discrimination based on any of the listed grounds in Article 27(4) of the Constitution is made and established, the burden lies on the respondent to prove that such discrimination did not take place or that it is justified. Judiciary is an essential component of our constitutional democracy, and judicial authority is vested in the courts by the Constitution. Allegations of actual bias or reasonable apprehension of bias or discrimination certainly raise a constitutional issue. The Constitution forbids unfair discrimination, regardless of the context in which it occurs, and irrespective of whether the perpetrator is a state or a private person. Article 27 provides that a person shall not discriminate directly or indirectly against another person on any ground, including grounds specified or contemplated in clause 4. The right to equality and freedom from discrimination is protected by international and legal frameworks that Kenya is a signatory to. The Constitution provides that general rules of international law, treaties, and conventions ratified by Kenya shall form part of law of Kenya. Article 2 of the Universal Declaration of Human Rights provides, quote, every person is entitled to all rights and freedoms set forth in this declaration without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. Furthermore, no distinction shall be made on the basis of the political, jurisdictional or international status of the country or territory to which a person belongs, whether it be independent, trust, non-self-governing, or under any other limitation of sovereignty. End of quote. This is echoed in Article 2 of the African Charter of Human and People's Rights, which states every individual shall be entitled to the enjoyment of the rights and freedoms recognized and guaranteed in the present Charter without distinction of any kind, such as race, ethnic group, color, sex, language, religion, political or other opinion, national and social origin, fortune, birth or other status. End of quote. Equality is one of the philosophical foundations of human rights, and it is intimately connected to the concept of justice. The concept is expansive, but at its core, it speaks the language of the Universal Declaration of Human Rights of 1948, which stipulates that, quote, all are equal before the law and are entitled without any discrimination to equal protection of the law. End of quote. Equality at its core communicates the idea that people who are similarly situated in relevant ways should be treated similarly. The European Convention of Human Rights defines discrimination as treating differently without any objective and reasonable justification person in similar situation. At the heart of the prohibition of unfair discrimination lies the recognition that the purpose of our constitutional and democratic order is the establishment of a society in which all human beings will be accorded equal dignity and respect regardless of their membership of particular groups or status. To this extent, the goal of the Constitution should not be forgotten or overlooked. The Canadian Supreme Court, analyzing the subject of discrimination, has the following to say, quote, this court has recognized that inherent human dignity is at the heart of individual rights in a free and democratic society. More than any other right in the Charter, equality is that concept is enshrined as a fundamental human right. Means nothing if it does not represent a commitment to recognizing each person's equal worth as a human being, regardless of individual differences. Equality means that our society cannot tolerate distinctions that treat certain people as second-class citizens, that demean them, that treat them as less capable for no good reason, or that otherwise offend fundamental human dignity. End of quote. The Constitution is the supreme law of the Republic and binds all persons. The Constitution enjoins the court to interpret the Constitution in a manner that promotes its purposes, values and principles, and advances the rule of law, human rights and fundamental freedoms in the Bill of Rights, and in a manner that contributes to good governance. This court is obliged to protect and promote the purposes and principles of the Constitution. The Constitution should be given a purposive liberal interpretation. This court is bound to adopt the interpretation that most favors the enforcement of the petitioner's right to equality and non-discrimination. Such an interpretation inevitably leads me to the irresistible conclusion that the exclusion of the petitioner from the ballot in the elections scheduled for 26 October 2016 is a violation of his rights to political participation and is also unfair, hence discriminatory. The next question is whether the petitioner considered defeat. The Supreme Court stated, if the petitioner was the only one of the if the petitioner was only one of the candidates and who had taken the second position in vote tallying to the president-elect, then the fresh election will in law be confined to the petitioner and the president-elect. And all the remaining candidates, underlining now, who did not participate or who did not contest the election of the president-elect would be assumed to have either considered defeat or acquiesced in the results as declared by IEBC, and such candidates may not participate in the fresh election. End of quote. The petitioner, as said earlier, participated in the petition number 1 of 2017 as an interested party and supported the petition which led to the nullification of the results. Can he be assumed as having considered defeat? I do not think so. Having contested the election, in that he participated in the petition as an interested party and supported the petition, he cannot be deemed to have his further affidavit, which has not been challenged or rebutted, explains the circumstances under which he issued a statement considering the reason why he retracted the statement. No legal basis to justify the fact and second respondent's division in the fresh elections. In view of my conclusions in above, I find that the petition has merits constantly issued that the petition has rights under Article 38, 27 and 140 of Article 3 of the Constitution have been and continue to be infringed, violated and or denied by the first and second respondents' failure to include him as a presidential candidate in the fresh election slated for 26 September 2017. B, an order B and is hereby issued compelling the first and second respondents to immediately issue a fresh Gazette notice and or amend the Gazette notice dated 5th September 2016 by way of a corrigendum to include the petitioner herein as a presidential candidate for the Third Way Alliance Party in the fresh elections scheduled for 26 September 2017. No order as to costs. Sorry and thanks for your patience. It was fairly long, but we have to go through it.
We wish to thank the
It was already by Friday, by the way. I said that only that I couldn't get you a day before finishing, a day before after we had it.
I know these adjustments as given in light of the we applied for elements.
Yes. Yes, Director. A copy of judgment you can get right away because I normally print myself and I printed enough copies. So let me record you. Yes, I record what he has said. I was signing the judgment. Yes, I've recorded it now. You can say that, Mr. Masharia. Am I right?
Yes, no, I'm sorry. I asked my friend to read.
Sir, I didn't record your attendance when I started. Yes, wait, I see what I recorded, even though. Okay, mainly for the second.
Mainly, I believe, is for the
second. So, Mr. Masharia was.
And I'm here for these purposes together with Ken Aukot.
Okay, I'll put you on record.
Yes. Sorry.
Sorry, Mr. Mutinda. Fine, have inserted the names in the quorum.
I don't know what my colleagues are saying about, but my instructor was on field.
That's really a legal right, so I don't even need whether I need to correct it. So I'm to record it. It's a right conferred by the law.
Yes.
So that one you can exercise. And I like it when people go up also to get that other opinion.
Well, I think Malord, when we did appear before you, we all grappled with very, very complex issues that faced you.
Yes.
I think you expressed that.
You didn't hear how I resolved them, you came late.
I have been following, my lord.
Yes.
But then the first right of appeal, my lord, then precedes the next petition about may be seeking a stay for violation of law.
Yes.
I know there's very limited time, my lord, but I know we could bundle in and toil and have a record of appeal, if my lord, and perhaps even proceeding that proceedings. I don't know whether the No. We actually.
And there you go. The court allowing Aukot's name on the ballot paper on October 26th, and that obviously affects not just him but any other candidate who took part in the August 8th general election and would want to be included in that poll. Therefore, now have the green light to do so. This a significant decision that will certainly affect what IEBC may have to say in the course of the day, coming on the back of Raila Odinga's decision yesterday to remove himself from that election contest of August 26th. The question now being, can they argue that they cannot remove Raila's name when a court has now allowed any other party that was running for the presidential contest on August 8th now to be enjoined, to be allowed into the 26th poll? And of course, the big question being, will this 26th poll happen anyway? We're going to be trying to get answers for you very shortly with my panel, but let's just give you a quick round of where else we are present. Adjacent to me, of course, that's the Milimani Court where we've been. Right below my image, you have the Anniversary Towers, where, of course, as you can see, police are standing by, expecting very much protests like those that are adjacent to that Anniversary Towers image, live from Kisumu, to be taking place as NASA continues with its opposition of this poll that was scheduled, or that is still scheduled, for October 26th, one that they say will not meet the requirements of the law. And joining me now in studio for analysis on this, we have Jared Jagedo, who's the MP for Nyando, just joining us this morning. To my far right, we have also Mark Bichachi, who is a political communication strategist. Next to him, we've been speaking to earlier Patrick Meru, who's the MP for Laikipia West, and of course Anthony Oluoch, who's the MP Madare. These gentlemen being advocates as well, and I thank you all. So let me return back to you, Anthony, because you were speaking. Let's get a quick reaction on what the court has said today and how this affects IBC, which is already in a very precarious position.